election meeting. You were concerned about the city and wanted to see some of the changes that we're now seeing since you've been commissioner. So let's talk about your zone a little bit, because in zone 2, there are some challenges, particularly as it relates to the Seabreeze corridor. What are your thoughts as it relates to Seabreeze Boulevard?
We've got to get Seabreeze Boulevard under control. There's a lot of nightlife, night activity.
The magistrate's running a little bit late. It's something we set as a special hearing. He's en route. Probably be another 10 minutes or so, he said. So, just so y'all are aware of what's going on, sit tight and we'll get things going when he arrives.
Okay, we will now convene special magistrate proceedings for the city of Daytona Beach on what I'm told is Valentine's Day, February 14, 2024. And before we get into this morning's agenda, I'm told there's a matter that we had addressed at our special magistrate proceeding, was it yesterday?
Yes.
Yesterday. Okay, and which case number are we talking about? Which of the,
It was case number 2 on the Special Magistrate's Appeals agenda.
okay, it's not Brooks Cleaner. Was this Made in the Shade?
Yeah.
Okay, is there a representative for Made in the Shade present? Come on up.
Go to the second podium. You can go to the other podium over there. The second podium over there, yes. There you go.
Yes, sir, if you would please state your name and be sworn.
I'm Eric Nordstrom.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right, Mr. Nordstrom, 34 North Halifax. What's that, just north of Main Street?
Yes, sir. Like houses up.
And you made an application to participate in the Bike Week 2024 Master Plan activities.
Sir.
And it's my understanding that you were lacking a few documents that you needed for your application.
Yes.
I'm sorry, did I preempt? Maybe, perhaps should let you talk for a while.
No, Mr. Vicalja, this is like pretty much a continuance of yesterday's set of special magistrate hearings for the master plan for those people who had been denied. And as you may recall, we had 4 cases that you considered, and you considered them because of their denial. The only way that they could participate, they had a right to an appeal and to come before you and seek that participation. Each of those had the similar situation in that it was based upon incomplete documentation for the most part. As I'm looking over to Ms. Askew. Okay, well, Ms. Askew is pointing out his is different, so I'll bring her to express that. But in any sense, at this stage, they have remedied their deficiencies. And so even with the remedy of their deficiencies, it would still be the magistrate's determination of whether or not they're able to participate. And that would be based upon whether it's the fault of the applicant or the fault of the city as to whose fault it is, whether it's their fault or not, the gravity of their deficiencies or failure to meet the standard. And what's the other one? Okay, so I'm meeting that criteria. So it would be those things that were stated. Oh, I know what the third one was. It would be whether or not they've had an opportunity and what opportunity they had to satisfy the requirements. And in this case, as I've stated, they have already remedied the deficiencies. I will turn to Ms. Askew. We brought this back before you because, as you may recall, we had 2 applicants who failed to appear on yesterday's proceeding, even though they had the documentation that would be what I'm referencing in terms of satisfying the requirements. And you denied them without prejudice, and you gave one option being delegating that review to the city manager, but also alternatively, if you were available, you would be willing to hear it. And since we had these proceedings scheduled already for today, is why he is before you today to get a determination. And if call Ms. Askew to come and address any other concerns you have regarding the review.
All right, well, it looks as though the Bike Week Task Force Committee meeting was January 5, 2024. It's my understanding the applicant here was lacking certain documents. I guess once the applicant was notified as to the missing materials, he made good on them?
Actually, for this case, it was not the applicant's fault. He turned in his paperwork prior to the deadline to the chamber. They failed to get that information over to the city prior to the meeting. He was not at the public meeting to realize they had not provided us with the information, so that's how he ended up with the denial. So he had already turned it in, so it was not his fault that he was denied. It was the fault of between the city and the chamber that the documents he turned in were misplaced at some point and never forwarded over for us to be able to have it on the agenda for the city commission to know that he had complied.
I would ask if you would identify
I'm sorry.
yourself and-
Rose, I'm so sorry. Rose Askew, project manager with the city of Daytona Beach.
Okay. Very good. Sounds like we've resolved the fault issue. And you should thank this young lady for being gracious enough to follow through on this.
And yeah, and I do.
To
thank her.
let,
I do, and I do,
so
and I
that
have.
another businessman gets to participate in
I
this.
do, and I have thanked her, yes.
Okay. As I stated yesterday, for those other folks that were in similar shoes as yours, every once in a while, the citizens find that the city of Daytona Beach can be pretty gracious when it comes to the treatment of its citizens, and this is a perfect example of it, so I do try to give credit where credit's due. Your appeal's granted, you get to participate. Good luck to you.
Thank you so much.
You're welcome.
Appreciate it.
All right, is that it for the Bike Week appeals?
Yes, the other, there was, said there was a fourth. The fourth is out of country. Ms. Askew will make some, probably utilize the alternative that you have provided in the meeting.
I'm around, albeit late. She can run me down whenever she wants. Okay, now. Will those representatives who will be testifying at this afternoon's proceedings please stand and be sworn?
Do you, sorry. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? I do. Thank you.
All right, case number 1 on our special agenda, Daytona Beach Resort 2 LLC. Is there anyone here on behalf of the respondent?
Good afternoon, Your Honor. I'm Chris West. I'm a corporate representative of the respondent, and we are represented by Tina Garcia, who is joining on Zoom.
All right.
Good afternoon, Special Magistrate Tina Garcia here on behalf of my client.
Good to see you again. Madam Secretary, could I bother you for a pen?
Oh.
You can just throw one down here. Thank you. All right, Counselor, does your client agree this violation existed or occurred as stated in the notice of violation?
I'm sorry.
No, we dispute liability.
Hang on one second.
I needed to make an announcement with regard to case number 1. It should be in the imposition of a fine. They were found in noncompliance at the last hearing.
That's not correct, actually. The previous hearing was continued to today for a special set hearing.
Did we take evidence prior to making the determination on the imposition of a fine, or did we solicit a stipulation?
It was cut short, if I recall correctly, and we were not allowed a full opportunity to put on our defense because the matter was taking a very long time and was hotly contested, as you may recall. Some of the residents had testified. My client did not get a chance to put on its full evidence, and it was continued until today.
What were you saying, Madam Secretary?
I'm sorry, the minutes show that Mr. Vikelja found the respondent in noncompliance and asked how much time it would take to come into compliance. Respondent was found in noncompliance and continued to a further date to be determined within 30 days.
Okay. Now, can anybody help me? Did I make that determination following an evidentiary hearing? Was it pursuant to a stipulation? Does anyone have a recollection?
Sir,
We did not stipulate.
my name is Leanne Wagner. I represent the Condo Association, which is an interested party, but not the respondent. And I do agree with Ms. Garcia. The respondent did not have an opportunity to to really present any evidence.
Okay.
But you were speaking with the code enforcement officer as to timing of obtaining a permit, possibly installing trap bags, things of that nature.
All right, well, when in doubt, I hear it all. So we'll assume there is no determination of compliance or non-compliance, and we'll go from there. So let's hear from our building inspector first.
Good evening, Mr. Vakelja. My name is Steve Alderman, Neighborhood Services Inspector for the City of Daytona Beach. My credentials are on file. This is a complaint-driven case for hazard falling beach retainer walls, dilapidated concrete deck beach access, hazardous exposed rebar, bolts and twisted railings, landscape overgrown, missing railings around empty pool, unsecure hazardous beach access to falling concrete, retainer wall, and dilapidated concrete beach entry, unsecure access under the concrete slab, public access to damaged empty pools and surrounding eroding pool deck, and unsecured access to uncovered water vault. First notice was October 31st, 2023. It was posted. Compliance date was due 12/1 of 2023. A finding of non-compliance, compliance next cutoff, which would be next month.
Okay, I'm looking at some photographs of a destroyed property. Is there any dispute that it's in non-compliance?
The dispute is to responsibility as to compliance, specifically.
Well, that's a different question. Do we have any dispute over the fact that the property is in non-compliance?
My client will speak, my client representatives are there and will speak as to the items that they have undergone to come into compliance.
That's a different question, too.
Yes. No, we don't dispute that the property was destroyed and needs to be remediated. Our position is that the incorrect party is here and that the association is an indispensable party who needs to be included in these proceedings.
All right, well, we'll get into that. Let's go one step at a time here. All right, you represent the association. I do. And I assume you're not going to deny that the property is in non-compliance.
At the last hearing, sir, you and Mr. Jackson both agreed that the responsibility goes with the property, and any agreement between the parties as to who takes care of that is separate and apart from these proceedings.
That's usually the case 99% of the time. I'm sure somebody's going to educate me as to why it ought to be different today. But in any event, it doesn't sound as though there's any dispute that the property's in non-compliance because it's blown to smithereens. Correct?
Correct.
Okay. Based on the testimony of the inspector and having heard from the respondent's representative, as well as the condo association representative, and most importantly of all, having viewed the photographs presented, I find the property to be in non-compliance. Now, the next question is going to be how long is it going to take to come into compliance, and then following that, I suspect we can start talking about who's going to do what when we start representing to the city what the city's expectation should be when it comes to coming into compliance. So let me take care of question number 2 first. Mr. Inspector, how much time should reasonably be required for this respondent to come into compliance?
Well, the entire area needs an improved safety perimeter installed just
Forgive
for
me,
this.
what property is, I'm pretty familiar with the beach. Which property is it? One across from Bel Air? Okay, all right, go ahead.
The initial safety perimeter permit should take about 6 to 8 weeks. There's a lot of other things involved in getting the permits. They did have a DEP permit, but it expired, so they do need to reinstate, if possible, that DEP permit or go to DEP and Volusia County and obtain permits for the entire construction site. Obtain a licensed contractor and engineer, have this initial safety perimeter permit within 6 to 8 weeks, and install east and west perimeter safety security, and install the cyclone fence or other approved material on upper west side, and trap bags or other approved barriers on the east side of the beach. And No, I won't go that far. Thank you.
Okay, well, let's leave it at that. And do me a favor, if you would, could you please, Madam Secretary, get a copy of what he was just reading from? I was scribbling as fast as I could, but I'm obviously going to have to familiarize myself with these milestones that he's already mentioned, and I'm assuming there will be more to come. I would just like to have that on paper so I can look at it, because I don't have that great a memory, and I'm not even running for president. Perfect. Okay, now, as to the, all right, let me try it this way. It would appear as though this is going to be a long-term project.
Yes, it will be.
And in my layman's way of saying it, looks like the seawall needs to be replaced. There might be any sort of other structural matters to be attended to. I'm assuming there's a pool that's been destroyed. I'm assuming there's a walkway or perimeter around the pool. And part of the reason I was asking for this is so I could get my hands on the first milestone the city could reasonably anticipate when it comes to mapping out what's going to have to be done to come into compliance. Because obviously, we're not going to be able to tell this respondent to come into compliance by the next cutoff.
Correct.
Which is usually no more than 30 days down the road. But we can start mapping out the milestones we expect to be brought into compliance. And then I'm going to turn to them once they and I are educated on what the city's looking at. And then we'll take it from there. So what would the city like to see reasonably within the next, whether, let's say, 30 to 60 days?
Well, at least an application to the DEP for the permit to work on the beach side, which is oddly enough right about the same time this one expired last year. They will need one for the turtle season, which is upcoming. That's going to be one of the first. An engineer has to be brought on board, and a contractor, licensed contractor that's capable of doing this kind of work is the one that should be obtaining the permit for the safety perimeter products that they're going to be putting on for safety. That includes the beach side as well as the side where the owners own the condos. Now, 6 to 8 weeks isn't unreasonable, I'm thinking, at least considering the size of this project, to get a contractor that's willing to take it on and obtain the permits to get the security things in place.
Okay, well, life safety is a big deal around here.
Yes.
So I'm assuming something has to be secured to keep anybody from accessing that area.
Yes.
And that's going to be mandatory. So, all right. What else would you like to see done, say, within the next 60 days? And by the way, if there are things along the way here that you think need to be accelerated, please educate me.
Well, the only thing I'm looking at that really needs to be done initially, as quick as possibly, would be the safety perimeters of this fence up on the condo level and the trap bags on the ocean.
Okay,
level.
now I know these respondents are going to want to know what that means. So when I'm walking down that beach, what does this safety perimeter that you're contemplating look like so everyone here knows what we're talking about?
Well, basically, the trap bags are within about 50, 60 yards of this particular structure as well. Just down the beach to the south, there's a whole row of them.
All
So
right,
everybody knows what they're for, and they're very
talking trap bags, what
correct.
else?
They're very popular, very common, and they can be used. They can be walled. You can put 2 rows and then another row and get a bigger wall. There's all kinds of ways to install them. These cyclone fencing, now that's going to have to be secured to a somewhat unsecure deck that's a little bit tougher, but it still is possible to bolt them in the ground because they still have to withstand storm winds, and because they're right on the
So have to
ocean.
withstand what?
Winds from the potential storms that are coming. So that's going to have to be done by permit. It's going to
That
have,
fencing is for what purpose?
pardon?
To seal off the north and south sides of this thing?
This is on the east side,
On the east side?
correct?
So that's in addition to the trap bags you're talking about?
Correct.
Okay, go
Yeah,
on.
this is, the condos, the lower condos are right on the pool deck. They can walk out, I think it's approximately 10 to 15 feet, step right into a pool.
Okay,
So that wall, that 6-foot cyclone has to go the entire width, and so does the trap bags as well. There's a lot of work going to happen on it, and the timing of the turtle process is also going to have to be considered. because we're at the same time they were last month when this expired, and it's going to,
Okay, how do
Yeah.
turtles factor into the safety requirements
Pardon?
we need for the humanoids?
they have to be informed, and they have to be limited by the DEP on what they do along the beach side itself. Whether they put what they can do for storage, what they can do for
So it's going to define how much work they can, how
Yeah.
much beach, if you will, they can
correct.
utilize.
But once those two things are in place, especially the trap bags on the beach, it's pretty secure as long as the turtles don't decide to put a nest right up against the trap bags. Like when I first took this over, there was a nest right at the corner of that particular picture right there,
Okay.
which was a mess.
And what, if anything, do we need to secure this damaged area from the condo itself? You just told me it's a pretty short hop from
Well-
the condo to the deck.
That's pretty much all that I can recommend. I mean, the trap bags will hold up that portion right there that you see as well, because they are going to fit
Everything you've
basically
talked
right,
about so far is on the east.
correct.
All right, what I'm talking about is, say, between the pool and where I don't know anything about the deck or the pool area. How much distance is there from the pool, say, which I assume is empty, to the condominium, to someone walking out a door? Is there fencing expected to be between the condo and the
Yes.
deck itself?
That's where the cyclone fencing goes. It's
Okay,
still
so
on
your
the east
cyclone
side.
fencing is going to be on the west side of this damaged area as well.
It's on the west side of the pool, but on the east side of the building.
Gotcha.
Okay.
Okay. So you're talking about fencing, you're talking about perimeter fencing around the whole damaged area, and you're talking about these trap bags.
Yes. The north and south sides of the property are pretty well secured based upon property lines. Walls are already up. Things are already good there. They're recommended and addressed in the original permit about 25 feet from the corner of the bearing wall that is breached to the west.
Okay.
So
And how much time should reasonably be required to make these improvements that you've just described to me?
6 to 8 weeks,
6 to 8 weeks.
I would hope for.
Okay, what is my cutoff? I don't have what is my cutoff for, this is February, March, April, I guess April. I'm looking 60 days down the road, I think. April 3rd, and what's the next cutoff after that, if you don't mind? So that would be May something. May 1st. Okay, all right. Respondents.
Thank you.
All right, now, your name again, ma'am?
Tina Garcia,
Ms. Garcia, and you are here on behalf of the property
Daytona
owner?
Beach Resort.
Pardon?
Yes. Yes, Daytona Beach Resort 2, LLC.
As well as Mr. West?
Yes, he's our client representative.
Did I get your name right?
Chris West.
Yes, West, thank you. All right, and you are Ms. whom?
Wagner?
Wagner? And you're here on behalf of the association? Okay. Now, I don't care if you all answer me individually, collaboratively, it doesn't matter. But I'm hearing from you've heard from our inspector what is the first thing that needs to be done in this process. And he is suggesting that this ought to be done by April 3rd. And we're talking about, it sounds like primarily securing the damaged area. We're not even talking about full repairs yet. We haven't gotten that far. First things first. Now, do either of you have anything to say about the reasonableness of you having that done by April 3rd?
There's a couple things I'd like to say, Special Magistrate, and then I'd like to refer to my client for some of the proactive measures that my client's taken already, and he could speak as to some of the procedures, if that's permissible.
Go right ahead.
Thank you. As you may recall from the previous hearing, the association and the developer are involved in a lengthy arbitration that has unfortunately taken way too long, and we hope that it is resolved rather quickly. My client disputes any responsibility for the repairs, which we believe are supposed to be borne by the association. And we believe that that will be the ultimate result as a result of the arbitration. Specifically, portions of the property that are called into question, in this case specifically, surrounding the pool, including the pool bar railings that are referenced, those are owned by the association, not by the developer, pursuant to an easement agreement. So we believe that the association is a necessary party to these proceedings and should be included as an indispensable party. I'd also like to note, with respect to this one and the subsequent case that is coming up, we believe that these code enforcement hearings have been brought forth through surreptitious means. The former treasurer of the association, Mr. Marquis, who you may recall, he testified at the earlier hearing, his wife called in and had code enforcement reports reported on this piece of property. She's part of the city government, believe that this is an abusive process and a back-end attempt by the association to leverage my client into settlement in the arbitration, trying to force us to incur costs that are not our responsibility and repair items that we have no obligation to repair through this means to sort of leverage a settlement in the arbitration. So we believe that procedurally, it is best if all of this is stayed, minus any life-saving issues, which we believe should be implemented quickly because safety is of the utmost importance for all parties involved. But with respect to ultimate responsibility and requirements for compliance, we believe that those determinations should be made at a later date. My client representative is there, and they have had some initial, I believe, engineer reports and inspectors who have come out and looked at the property and come up with a plan. Indeed, the association has already levied assessments to implement these very repairs, and we're willing to give them the plans and they can move forward with repairs. They simply refuse to do so. And we put up fencing in the interim. I believe he opined as to the usefulness, as to the sandbags, and I would defer to my client as to the efforts we have taken to mitigate any risk to life and safety and the steps moving forward. So I'd like to turn it over to him and he could speak a little bit more as to what we have conducted and the steps that we believe are reasonable and what the engineer has discussed as possibilities for the property.
Is that you?
Yes, sir.
What's your name?
Harrison Merrill?
Have you been sworn?
Yes, sir.
All right, go ahead.
So all of this damage occurred in 2022 from the hurricanes. A lot of the stuff Mr. Alderman just mentioned has already been done.
Such as?
From the hurricane, we immediately contacted an engineer, CRA, John Adams, had him come out to the property following the loss, came out, made recommendations of what do we need to do safety-wise to make sure that people cannot access it from the outside to the outside of the building, also from the beach to the seawall. So that was the first step, and we shut down the entrances to the outside. We made a fire lane with fencing, so you could go out of the building, still have what the fire marshal needed to get outside the building. We separated it into two. The south side of the pool deck is where it sustained much more damage. I have a diagram right here, if that would be helpful for you.
Thank you.
So on that diagram, the south side of the pool and the kiddie pool is where the significant damage to the seawall occurred. There's damage to all of it, but that's where it's noticeably damaged, where it's fallen over. So we put a fence between the north and south pools. And on the north side is where you can go outside the building. There's fencing to take you to the emergency exit so no one can get to the pool area.
North pool as well.
On the north pool side, correct. This is all
Both
north.
pools are damaged.
North pool is fine right now.
Pool's fine. What does that mean?
The
Usable?
no, it is.
Okay.
It's not filled, but it's not. The erosion hasn't come to the pool yet.
It's not as severe. on the north
Correct.
side.
Yes,
It's
sir.
Still damaged.
Still damaged. Yes.
Go ahead.
And so there's a fire exit where you can go out there. On the other side is where the significant damage occurred, where the seawall actually collapsed in several places. and that's what we had the engineer inspect, look at it. But we put up all the safety fencing for our property. We put it along the seawall. It has fallen down several times. I know over the last several.
Talking fencing now.
Correct. Yes, orange safety fencing that goes up along the beach side so no one can enter in, and also on the inside. There is still an area, as Mr. Alderman mentioned, that is the condo property, which are the balconies for about 10 units. We do not have control over that area, so we've put safety fencing up. It's been taken down, to my understanding, several times. So there is a safety issue currently on the fencing on the part of this whole thing that is owned by the condominium. That's why we got into it's really an issue of us and the condominium, because they own some of the property. We can't put up fencing on their property, but all the safety fencing's been put up. Then with the engineer, we've had them lay out what are the improvements needed to get the seawall back. Took about 3 to 4 months to have them come back with that report. We went to a general contractor, very reputable in the area, to give us a quote and time frame of what that would be. We packaged all that together. We knew last year we were in trouble with the turtle season. We submitted that to the association, I believe in May or June. They had a special assessment of all of the owners, collected the money, and then in July decided they're no longer responsible for it. We've owned this building for 32 years. And there's been other hurricanes, there's been seawall issues. Never has it come up where they're not responsible to fix the seawall through the easement agreement. July, it stopped. Nothing has been done since that time. We still have the contractor on standby, but it's a funding issue at this point of liability. And there's been a new arbitration that continues to drag on that hopefully gets resolved quickly. But we have everything in place. We have the contractor, the engineer. A lot of the safety measures Mr. Alderman mentioned have been put in place. Any more that we need to do, we're happy to do and get up as soon as possible, and we can definitely do that within the 60 days you mentioned. But again, it comes down to a funding issue of they collected the assessment, and in July, for whatever reason, they decided they were no longer responsible or wanted to try a different route to shed responsibility.
Why do I have two cases here? What's the second case?
The second case refers to a parking garage issue, which we can also discuss if you'd like to get into that one now.
I know you heard from several voices. We previously, the second case was one that had been ongoing from months prior. It's regarding the balcony and the garage.
So the second case and the physical boundaries of the second case are separate and apart from the first case?
Yes.
Okay.
Yes.
Okay. Okay. So, just to review the bidding before I go any further, we're in agreement that the property is in non-compliance. We're in agreement, at least as far as the city and the property owner is concerned, as to the first task to be attended to, most of which have life safety considerations to them. And I'm hearing a property owner saying they're ready to proceed, and I'm hearing a property owner saying they're willing to work within the time frame or concur with the time frame suggested by the inspector for these initial matters, which was April 3rd. Okay. Who else wants to be heard on this?
Thank you, Mr. Vikelja.
Okay, Ms. Wagner would like to be heard on this.
Yes, thank
Okay.
you. As counsel for the association, it is shocking to hear that the developer now claims that the association owns any portion of this property. Because what it does have is easement rights under an easement agreement that allocates financial responsibility for certain repairs. The reason that we remain in protracted arbitration, as I understand it, is because while the association was willing to advance the funds to pay to repair the seawall, it did want an agreement with Mr. Merrill that in the event that the arbitration proceeding ruled that the association was not responsible, it would be entitled to be compensated for any monies advanced. The association has a trap bag permit sitting on Mr. Merrill's desk that has not been signed for whatever reason. So the association is attempting to do everything it can to assist in these repairs being made, but is being met with resistance. And as far as this being the result of an abusive process or any surreptitious means of seeking code enforcement, you have the pictures in front of you. Anyone walking on the beach or going past this property can see the condition. That's an absolutely outrageous claim, and we vehemently reject that claim.
Okay. Who owns the Daytona Beach Resort? Mr. Merrill. And you own,
That's not exactly correct.
well, I wouldn't think, okay, Counselor, everybody be quiet. Counselor, come on up to the podium for a second.
Listen, I'll grab you.
Counselor, I want to talk to the lawyer here. Okay. I'm hearing easements, I'm hearing this, that, and what have you. It sounds to me like I'm getting ready to hear about competing property claims. And the reason I ask is because I don't even know that we have all the parties listed that perhaps should be listed on this notice of noncompliance. So, what does Mr. Merrill own?
It's portions, the Daytona Beach Resort, which Mr. Merrill is a manager of, owns portions of the resort. And it actually has taken our surveyors quite a bit of time to be able to determine what portions are what. And it's a lengthy survey. Part of what the
Okay,
nature
do me
of
a
how
favor and kind of translate this into layman's language geographically as far as what I'm looking at here.
Can you out and show what's exactly on?
Does he own the kiddie pool?
Yes, we own the pool deck area.
Okay,
What the association owns by the kiddie pool that Mr. Alderman mentioned with the condominium property and owned by the condominium, right here, there are balconies that line up against the pool deck area. That is owned by the condominium. That is what, there is no safety fencing from those guests or owners going out into the pool deck. That's what's owned by them. The pool deck is owned by us, and there's the responsibilities to pay for it are all designated out in the easement agreement. But the area
okay,
is owned by us.
stop right there. Easement agreement. Ownership, easement, apples and oranges. So what you're telling me is there's only one owner of the property, and that's just Mr. Merrill.
No, because the
Aside from whatever facilities are actually dedicated to the condominium association.
No, we own, if you're looking at building square footage, we own 12% of building square footage. The other 88% or so is owned by the condominium.
I understand that. So what, the common elements are still owned by the owner?
The commonly used facilities are owned by us.
Okay,
And the balconies are limited common elements that are owned by the association.
okay. Are the balconies part of case one?
Yeah. But no, they're not. That's the case too. Is
Okay,
about-
then I don't need to talk about balconies anymore.
Well,
So is,
case two is the garage. I'm sorry, could you take that, Tina?
Thank you. My understanding, and the client can attest to this, is that there's some pool railings around the pool that enter onto balcony property. If Chris could clarify that, that's my understanding.
And that is what Mr. Alderman was earlier of the condominium portion, which is the balconies going out to the pool deck where there's access.
all right, well, let's focus on the pool deck, which appears to be the subject of case one. Is that not the subject of case one, the pool deck? Yes. Okay.
We own,
Focusing on the pool deck, we own, who is we? We is Daytona Beach Resort 2 LLC?
it's Daytona Beach Resort,
Daytona Beach Resort
correct.
owns the pool
The
deck.
pool deck, which includes.
The pool deck that's
seawall,
all
pool-
obliterated pursuant to the pictures I just looked at.
Correct, which
And
is,
so it's the owner's responsibility to come into compliance.
yes, sir.
Okay. So, and we're in agreement that it'll take 60 days to at least do the preliminary safety matters that we've already addressed. Okay? So, I'm going to telegraph my punches because I can see a lot of this people in these rooms want to throw punches here. so I'm going to telegraph mine. Well, I'm getting ready to rule that order that the owner come into compliance within 60 days with regard to the life safety matters that have already been delineated, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Now, either of you can try to explain to me why I shouldn't be doing that.
I think that's fine. I just want to clarify on the pool deck, I assume that includes the seawall, the pools, and everything shown here in yellow would be considered the pool deck, because that is.
I'm assuming that's correct. Is that not what we've been talking about?
If I may, I think the western portion of the pool deck, which is a safety concern, which the gentleman from the city, Sullivan, mentioned as a safety concern for access, I think some sort of fencing, I can't remember what type he described, was suggested that they put fencing along that side. I'm suggesting to you that I think that is the property of the owners of those condos, the COA, the condo association. That if we put fencing there, we would be trespassing on their property, which.
It's been taken down, correct? Numerous times.
But
Yes.
but it's not there. But if he's suggesting he wants additional fencing there or put back there, then I think you need the owner of that property present to speak to that.
Can I just
Who are
have
you?
everybody
I can clarify this very quickly.
Go for it.
just have to tell them
State your name and be
into the mic.
sworn.
David Marquis, I've been sworn already. The issue with the pool deck is correct. If the fence is set 1 foot into the pool deck area, along where the balconies are, no problem. It's a joint. The line where the balconies and the pool deck are is a line. That's where the fencing needs to go up. It can't go in the balcony, so it's got to be on the pool deck. So it can be a foot off of the balconies. It still accomplish the purpose and be on 100% on Daytona Beach Resort property. And the fencing that was put up before was the orange or snow fencing. We're talking cyclone fencing needs to go up, and that's the debate right now.
We're allowed, we're happy to do that. Or we can attach it to the fencing if we're allowed to do that as well. I just wanted to clarify the pool deck area because in the arbitration, what is being disputed these areas aren't part of the pool deck. So I just want to make sure that we're.
All right, well, I'm going to ask
about the
this
same
one
thing.
question one time for educational purposes, and I know I'm going to regret it. I take it there's an easement agreement and there's a dispute over who's responsible for what as a result of this easement agreement. Is that correct?
Yes, sir.
And I take it the easement agreement is what permits the association to use what would otherwise be the common elements, specifically the pool deck with regard to this particular condominium.
Yes, sir.
Okay. And y'all are fighting over who's responsible for what? Which, with all due respect, I don't want to offend anybody, I couldn't care less about. Okay? I'm here, and my primary concern is not only the persons who utilize that property, the persons who occupy that property, but also everybody that can access that property from the beach side as well. That's my concern. And as is almost always the case, our line of communication is the city to the owner. The owner may have countless agreements with tenants, easement holders, what have you, that are between the owners and their tenants and what have you, but have nothing to do with the city of Daytona Beach and who they hold responsible for maintaining their property. Okay, so that having been said,
And if I can just provide the legal support for that, Mr. McKelvey, as it relates to our land development code. Excuse me. Our land development code in Article 1, Section 1.6.5 provides that, I'm sorry, I said 5, that's not correct. Section 1.6C, as in Charles. It says relationship to private agreements. Nothing in this code is intended to supersede, annul, or interfere with any easements, covenants, deed restrictions, or other agreements between private parties, but such private agreements shall not excuse any failure to comply with this code. The city shall not be responsible for monitoring or enforcing private agreements.
couldn't have said it better myself.
And
That having been said, I'm going to order the respondent, help me with this, Mr. Alderman. And we're not done talking, by the way. We've got more to talk about. Just trying to take care of what I can. To obtain a DEP permit,
Correct?
obtain whatever permits may be required from Volusia County.
Correct?
I'm talking about life safety. I'm talking about the pool area. I'm talking about the beach area right now. Obtain a licensed contractor and/or engineer to make sure whatever improvements are done with, in accordance with the city's building and zoning ordinances, and have the initial safety perimeter permit obtained and the perimeter in place by April 3.
Correct.
Have I said that correctly?
Yes.
Does everybody understand what we're talking about?
Yes, sir.
All right, I'm going to order that. Failing that, the respondent, in this instance, Daytona Beach Resort, will be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Now, I understand there's a dispute between the property owner and the condo association. How, if at all, does that dispute impact my jurisdiction or what I'm here to do?
I think
That's my only interest in those matters.
totally understand. I think the safety issue. The fact this property is operational, we shut down everything we operated, the 12% we have, we've shut down. This property shouldn't be open, safety-wise, with what's going on with the seawall, with the garage, with the elevators, with numerous other things. We can't close it down. We don't have that right. We've closed our areas down, but our concern safety is the longer this goes, the more and more this property's at risk, and there's owners, and there's also owners that rent to guests who have no clue what's going on, that are in an unsafe situation. That's our concern as the owner, because if we own the whole property, it would be shut down until these repairs are made, regardless of how long arbitration took. That's our concern, is the safety.
Counselor, the same question to you.
I'm again surprised that Mr. Merrill is raising safety issues when we have an engineering report that says something completely different from Daytona Beach Resort. We have asked that the engineers get together and make a determination as to what is a prudent course of action, given these conflicting reports. The association is certainly not flouting any safety regulations. It's not, trying to do things that are dangerous to the owners. Everyone, again, at the property can see through the miracle of sight that there are safety issues. This is not a surprise to anyone, but no one is being put in a dangerous position. So we, again, firmly reject any contention that the property should be shut down. And I'm surprised that that's being raised today, quite frankly.
Okay, well, what I'm not hearing,
I was just going to suggest there's two engineers' reports. She just, I think, called them conflicting. But the way I view both of those reports, I think is clear on its face, is that there are safety concerns. Now, one gives a path of how you can do it, but then the engineering firm gives all the disclaimers in the world, saying, don't hold us responsible, and we're not saying that it is. I think it's very clear. And as you've indicated, it is unsafe.
Okay. And we have those reports, because I'm surprised to hear conflicting reports.
slow down, people. We don't need to express any more surprise.
Ms.
What?
Mr. Coucher, I have the chief building official for the city, Mr. Glenn Urquhart, and we're aware of these conflicting, and I'm not trying to
Get
pick
ready to
pick
take care of
word
it for you.
on these plans as well. And if you would like Mr. Urquhart
Nope.
to speak to any of that, he would
Nope.
be happy to tell you the position of the city.
Nope. Because I'm already there.
Okay.
And I don't mean the gentleman any disrespect. I know what you're talking about. That's where I was getting ready to go to begin with. So, I haven't heard from the association's representative any problems I have with jurisdiction or ability to proceed here. So that having been said, I've made my order. Now, with regard to your engineers' reports, whether they be complimentary, contradictory, I don't care. This gentleman, and now the building inspector we've just heard mention of, what was his name? Okay, Sounds like they're going to be the arbiters as to what, if anything, satisfies the owner coming into compliance. So both sides, or anyone who wants to be heard for that matter, needs to funnel whatever they want to Mr., one more time? Urquhart. All right?
I do think he would want to probably speak to the scope of what, but.
Well, in any event, between Mr. Alderman and Mr. Urquhart, you're not going to be pitching your competing engineering theories to me. That won't do anything. You start with Mr. Alderman, and then you move on to Mr. Urquhart, because these two are going to be the arbiters as to what ultimately constitutes compliance. All right? Now, one last question, and I'm really not trying to continue to stir this hornet's nest here. Does this easement agreement that I've heard mention of require that the association be joined in this matter? And I guess that's especially well, they are joined in the next one. Okay.
Right.
So they are joined in the next one, because I was going to mention the balconies. Balconies are in the next one. So I guess you've already thought about that, and you don't see any need for the association to be in on this one.
That's the position of city staff.
That's fine.
yes.
Okay. All right.
Okay.
So I'm getting ready to move off case one. I'm moving off to case two. Anyone else in this room want to be heard?
Since Ms. Garcia mentioned me and my wife in her statements, yes, my wife does work for the
I'm
city
getting
of
ready to tell
Daytona.
you I don't care.
Oh, I know, but she's on leave right now. Her boss knows. She's a property owner. She has property rights. She filed a complaint along with several other owners and myself about this. So that, I'm not even sure why Ms. Garcia brought that up. And me being treasurer
No, I really don't know
previously-
why you're bothering to bring it up, because I'm trying to cool the temperament in this room here rather than stoke it. And I appreciate your
and I appreciate
concern,
that.
and I appreciate your indignation. Understand all of that. Okay? Now, all that having been said, sounds to me like y'all need to funnel whatever recommendations you have to Mr. Alderman and Mr. Urquhart. And told you I wasn't running for president. Mr. Alderman and Mr. Urquhart. And then if he can't or they can't resolve the matter, then it does come back to me and I'll resolve it myself. And at that point, I'll be a lot more educated when it comes to the engineering nuances of the Daytona Beach Resort. Is that it for case number one? Did anyone else want to be heard on case one?
Yes, correct.
And if you're going to come up here and repeat something I've already heard, don't bother me. You got something you want to add? Come on up. Yes, sir. You need to state your name and be sworn by our secretary.
Chris Savino, and I own one of the units, and it's on the pool side, one of the
I'm sorry, sir.
units.
Can you spell your last
Sorry.
name for me? Spell your last name for me.
Savino, S-A-V-I-N-O.
Do you swear or affirm the testimony you're about to provide is the truth, whole truth, nothing but the truth?
Yes.
Thank you.
All right,
Speak
Mr.
into the mic, you
Savino.
can move it.
Go ahead.
I own one of the units. I don't live there, and rent it out most of the time. And the association collected money to fix the seawall, which I paid, plus other repairs. And nothing's been done, just been bickering. And I have not listened in on the meetings because it's just accusations and yelling and screaming. They're not getting anywhere. It's constant lawyers suing each other, and just, it's crazy.
Did I mention I'm a lawyer?
Excuse me? So, and then I get this notice where there's a meeting February 22nd, and they want to take the money they've already collected for the seawall, and they want to fix the elevators. Now, it doesn't make sense to me because the ocean is unforgiving, and tomorrow we could have something to take it out.
Gravity's not.
But the elevators, I know they need repair, but they've known this for over a year, and all of a sudden, everything has to be fixed right now.
Well, unfortunately, I can't help you with the internal mechanics of your association. And I'm not saying that to be flippant or disparaging. Just It's above my pay grade, that's all there is to it.
Right.
You need to take that up with your association, that's as much as I'm gonna say on that.
Yeah, hopefully a new association.
What part of that's as much as I'm gonna say on that did you not understand?
Yes,
That's as
all
much
right.
as I'm gonna say on that.
Thank you, Your Honor.
Good luck to you. Good luck to all of you. Didn't you were different?
Well, it'll be different.
Okay, if you would please state your name and be sworn.
My name is Carolyn Marquis, Unit 116.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
I just wanted to make sure, because there seems to be a lot of confusion relevant to the amenities. The owner separated those amenities and kept those as the developer retained property in a separate LLC. He can close them, he can open them as he wishes, he takes loans against them, or he can sell them off. The COA has very little power to enforce any of the rulings on the developer retained property, or they would be fixed by now. That's why they have been trying to offer the trap bags or raise the money to help loan to him to fix the seawall. He has been inactive and full of excuses. The owners of the privately owned condos have experienced extreme interference with their property values and public safety, as have the beachgoers. We would like to make sure that there's a tight course of action and repair with oversight by the city, and I appreciate your time on this matter. Thank you.
Thank you. Okay, case number 2, Daytona Beach Resort LLC and Daytona Beach Resort and Conference Center Condominium Association Incorporated. Am I to assume we have the same representatives for the respondents? And
That would be a safe assumption.
Good to see you again. And in this instance, we have the owner and the condo association present. All right, and I now know that there is a parking garage that's involved, and apparently there are also some balconies, but all that having been said, I will now defer to our inspector. Mr. Inspector, this matter is here for the imposition of a fine, is that right?
Yes, sir.
All right, go ahead.
Inspector Kevin Yates, my credentials are on file. This case, they were first notified of this case November 6, 2021. Currently, while there is ongoing work on the balconies, which is permitted and slated to end, I believe, at the end of March, the beginning of April, there has been no movement on the garage, nor has any timeline been put forward of when the work will start or can start. Given this and the value of the building, the city is asking for a fine of $250 a day to a maximum of $505,000.
And you are looking for both of these respondents to be fined?
Yes.
Okay. All right, let's hear from the owner first.
Thank you.
Garcia?
Yeah, I'm here. Sorry, I had to hit unmute. We reiterate many of the arguments we made in the previous case. I don't want to waste the precious time here on Valentine's Day stating what I just stated for case number 1, but we believe that these matters should be stayed until there's a final ruling in the arbitration, given the significant disputes between the parties as to ultimate responsibility. My client is there, and he could speak as to some of the efforts that have been made by them to repair the vast majority of the issues with respect to the parking garage. They've undertaken significant steps, specifically as to the exterior cosmetic issues. Our understanding is that the only remaining issue that is left with the parking garage is with respect to puncture shearing on the columns, which is an issue that came up from code enforcement well after the initial notice and the first several hearings. It's a subsequent one, and they'll speak about that a little bit more. We believe a fine would be improper at this time unless both parties are held jointly and severally liable, given that the notice is sent to both entities, both the association and the developer, in lieu of a penalty, what we believe is perhaps most equitable, given the circumstances with respect to the dispute and liability, is a withholding of authorization for use of the property, which is permitted under the Land Development Code, Article 10, Section 10.4. The city may deny or withhold authorization to use the structure and improvements, specifically the parking garage, until any violations are cured and corrected. We believe that there are safety concerns and that the best remedy to protect all owners is to shut it down. And I'll defer over to my client to discuss the steps that have been taken and what our engineer has found.
Just one small clarification before we do move forward. The violation is for the cracks and breaks in the concrete on the interior and the exterior of the garage. The puncture shearing is something that their engineer came up with and said was an issue. That is not something the city has cited.
Okay, the cracks and what on the garage?
Cracks and breaks on the interior of the garage.
Cracks and what?
Breaks to concrete. Yeah, basically there are lots of cracks and breaks on the interior that were observed.
Who owns the garage?
Daytona LLC, Daytona Beach LLC.
Why is the association a party?
Because I also cited the balconies you'll see that are being worked on, so I cited the entire property.
Gotcha.
And Mr. Vikelja, if I could speak to that, we were not added as a party to this action until February of 2023. The developer had already been in front of you for various violations. We were added last February, and I think Inspector Yates would agree that the association has done as much as it possibly can to complete its work. It unfortunately is subject to the whims of its contractors, but we have asked a number of times for the proceedings to be bifurcated so that the association's completion of its work could be acknowledged without a fine being imposed. I've been told that because of whatever position of the city, which again is completely fine and within the city's discretion, we cannot have a bifurcated proceeding.
Ms. Garcia, why haven't the problems with the garage been rectified?
My client has rectified many of the issue with the garage, and he can speak to that specifically as to the steps that have been
Folks,
undertaken.
I really need to hear this. I need to be shopping for Valentine's presents, so don't keep me here any longer than I have to be. Go ahead, Ms. Garcia.
Yes, I was just about to turn the floor over to my client again so they can discuss many of the repairs that they have undertaken.
Okay, what I'm interested in are the failures to repair that the inspector is talking about that continues to keep your client in non-compliance. Are you going to give me some extenuating circumstances as to why those matters have yet to be attended to?
My understanding is that the vast majority has been corrected, and what remained was the puncture shearing from their discussions with the code enforcement, and Mr. West can speak to that further.
Mr. West is going to speak to that further.
Yes, and we'll present pictures of what we have done.
I don't care what you have done. You're here because what you haven't done. Right now, we're talking about cracks and breaks in the garage.
And I do want to clarify that I do agree with them that they did take care of those issues on the outside at this point, and they have been done to
And we will take
satisfaction.
that into consideration when the time comes,
Yeah, there's
which
been,
is sometime after compliance. So where do we stand on the cracks and the breaks in the garage, which I understand are all that need to be resolved with regard to the garage?
and just to clarify further, basically what's happened is they're saying, their engineer says they need to do additional work. The city did not tell them that. But if they have an engineer and their engineer is telling them that the only way to resolve it is to do that, then that would be something that is at their discretion.
All right, well, let's try to find out what the story is with regard to the cracks and the breaks in the garage.
Well, and we do want this, I think safety is the imperative issue here. This property is unique, this garage specifically, in that I want to make sure Ron understands this, that there are residences above this garage. There are people that are above this many hours of the day. I don't know how many dozens of people, dozens of rooms that exist above this garage. So we want it fixed. We want it fixed correctly. We want it fixed safely. The superficial, I think one of the items that was pointed outside would look like that I saw today on property was where a vehicle had run into the side of the building, which was cited as an issue. To me, that's appearance, aesthetic. It has nothing to do with safety. But we want an engineer who's looked at it and have proper construction work done for the safety of everybody involved. We are not generating revenue from this. This is a valuable piece of property that we should be generating revenue from in parking, and we're not right now because we've shut it down on our own and our own initiative because of the safety concerns. And that is imperative and paramount to our client.
How long would reasonably be required to fix these cracks and breaks in the parking garage that you've identified? I don't know if this is a weekend job or a 6-month job.
If it requires no structural, 6 weeks would be a reasonable time frame. If it requires a structural engineered design on its own, is probably 2 months. And then bidding out the work after you get that, because you can't bid the work until you get the structural design. Now, of course, my contention being that that's what we've asked them to do since November 6, 2021. And they're just not doing it.
Okay. So if it doesn't require a structural engineer, you would expect the work to be done in 6 weeks. If it does require a structural engineer, it would be some 8 weeks after plans or what have you.
I would say between 2 and 3 months total time frame to get the work finalized if it requires a structural engineer.
Why haven't the cracks and the breaks in the garage been fixed to date?
Because with the engineering report we mentioned with the puncture shearing, it is shown on there, it is unsafe for that garage to be open, so it's been shut down. If we brought equipment in there, then that would be it would be an unsafe environment to fix anything on the inside. If it's something we can do and get signed up, we are happy to go in there and fix any of the
Can you explain this
cracks.
to the city?
Yes, we have.
Okay. And have you, in the city, come to any sort of a resolution as to what needs to be done?
I'd like to speak to that if I may. I appreciate Mr. Yates has been very kind and professional this afternoon. And going forward, I think in fixing these, what we would request is that the city provide a supervisor to manage this repair with these items going forward. Well, let me go further.
You want your own private inspector designated by the city to babysit your client while they make repairs?
I believe
overdue
Mr. Yates,
already?
I believe Mr. Yates has a complaint against him with the internal affairs based on his conduct at the last visit he had, which I saw the video, which appeared to it was a heated discussion among everybody. But what I'd like to say, and you've mentioned today, bringing the temperature down, I think it'd be most effective for everybody going forward is that somebody else be involved in this aspect from the inspector's office on this case. I don't know why they would have an issue with that.
Okay. Do we have cracks and breaks in the garage?
There are.
It is very.
They haven't been fixed.
Well, it is very. We would love to know what those are, where those are, and what's needed to be done. Because when you look at any,
You not been in your own client's garage?
yes, we have been in there, and we are not sure where these exact issues are. There's issues with the puncture shearing that we're aware of, that we've had an engineer said these columns are issues. If we can be told if these are cosmetic things, it's a very easy fix. But we're not sure if we can be told exactly what columns, what needs to be fixed. We're happy to do anything we can. The puncture shearing is the one that's a much bigger issue that we can't resolve right now. But anything for the other ones, we're happy to do.
Who on your side is going to be the representative that's going to explain to whomever what work needs to be done, why it needs to be done, and how long it's going to take to do it? Is that you?
That would be Natasha and Kevin Montgomery on property.
So these are the two, let's just call them owner representatives, most knowledgeable about what needs to be done how long it would take to do it, and how involved the process it would be.
Yes, sir.
Okay. Who at the city would be the person looking at whatever they brought? Because what I'm hearing here, in between all the sound and fury, is a dispute between the owner and the city regarding what it takes to come into compliance. That's how I translate things that are taking place here. So, I hear our inspector, he tells me it should be done in 6 weeks. I hear from these people, they go, nope, it's much more involved than that. And we've got an engineer, and we've got a representative, we'll be happy to show you what it is, and we want to sit down and resolve it. And if the end result of this is a better mousetrap, then I'm happy to do it. I don't care. So right now, who is the representative for the city of Daytona Beach who theoretically would need to sit down with these people to take a look at what they're talking about?
Mr. Vacaljo, first of all, we know nothing about any kind of internal affairs regarding Mr. Yates.
Don't bother me with that. I'm not.
Mr. Yates is the inspector on the case.
Pardon?
I said Mr. Yates is the
Okay.
city inspector on this case. And as we've stated, it's been going on since 2021. What I don't understand, if I may, just from what I just heard, is are we being told, or is the question of the respondent whether they can just not do a repair, and it's because they physically believe they can't go in the building? Is that what in the garage? I'm trying to understand what they were saying.
It's my understanding they're not appreciating the significance of the cracks and the breaks that Mr. Yates is referring to, and are also pointing out other deficiencies that they would like to attend to, that I get the impression would bring everything into compliance when all that was said and done. But right now, they ain't talking to you, and you ain't talking to them, and everybody wants to fire each other.
I think we started this with issues of timelines and all those types of things. Ultimately,
Okay,
our
well,
building
I'm a special
official.
magistrate. So now the question is, if I think these people sound reasonable enough in saying fixing the parking garage isn't just a matter of splattering some concrete into a crack. It's going to be more involved than that. And we're not sure what he's talking about. And since nobody's doing a real good job of communicating here, then I'll babysit the communications myself if I have to. All I'm asking for is who's the city representative who's going to be the person most knowledgeable, who can agree or disagree with whatever I think is the common sense thing to do. Because I'm more interested in getting the job done than I am the ancient history.
Mr. Yates is the one that would ultimately be reporting back to the magistrate. We have a line of people reviewing plans, reviewing as far as all the way up to our chief building official. So ultimately, it's our chief building official. But the person that's going to be probably most relevant in terms of communication and involvement with these, whoever's working on this property would be Mr. Yates.
Okay. Good.
I'm happy to
You
share
answer?
you an email from Lieutenant Shirillo of the Daytona Police Department. Happy to show it with you, where a complaint is being investigated.
All right, well, I will defer to the city as to who its inspector is going to be.
Certainly, if there's some,
And it is not within my purview to start telling the chief building official or anyone else who he assigns to one job or another. So I'm not so I appreciate your proffer, if you will. All right, so is the parking garage the bulk of case 2 that we're talking about?
Yes.
I mean, I'm going to talk about the balcony.
Yeah, I believe the majority of,
If I should
yeah.
plan on spending the night here.
No, I think the balconies are a settled matter. We know when they're going to finish. There's no questions left on those.
Okay, good enough. All right, then before I say anything else, now we also have to address balconies. Okay, and it sounds like we're in agreement that the balconies are the responsibility of the association. Okay. How much time should reasonably be required for the association to repair those balconies?
The April cutoff.
April cutoff. All right, our building inspector has suggested that the association ought to have those balconies repaired by April 3rd. What say the owner or perhaps more importantly, the representative for the association as to whether or not that's doable.
We believe that everything should be done by then.
Very good. Okay, is there anything else we need to talk about with regard to the subject of case number 2?
Not that I'm aware of.
All right, then I'm going to do the easy part. I'm going to order the respondents, plural, because right now, as far as I'm concerned, you're both equally responsible for everything, to come into compliance with regard to the balconies by April 3rd, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Now, okay, Counselor, before I go winging it here, what is the most efficient way for us to hear them out and hear him out with regard to the compliance on the parking garage? And I appreciate your indignation, but just spare me the history lesson. Is it me? Is it him? Is it a chief building official? Is it an engineer? I'm ultimately going to make the decision. If you want to just schedule another hearing, I'll hear from that side, I'll hear from him, and then I'll say, okay, that makes sense, we're going to go that route, and this is how much time they have to get it done. Or I'm going to say, that's ridiculous, I don't see where that's necessary at all. He's right, have it done by this time.
Yeah. Mr. McKelvey, I don't believe we're really in any situation different than we've been in before, in that the inspector has expressed what he believes is compliance. He'll meet with them if they need to see what and determine what those things are. If they believe they need to go over and above, and that's a necessity, we won't do anything to stop them from going over and above.
Well, I already know what the inspector has to say, so now the only thing I don't know is what I have to say. So I guess I need to meet with them. I need to hear their explanation.
Right. So our typical follow-up that we would do
Typical follow-up.
as
That's
a
what I was
progress
going
report.
to suggest.
Currently. Yes, I agree with that, Mr.
Okay.
McKelvey.
Then, subject to the agreement of the association and the owner, I will schedule an appointment down here at City Hall to meet with you, whoever. Bring whoever you want. Mr. Yates is welcome to come too. I think I already have an idea as to what his opinion is, but he's welcome to be there too. And I'm going to hear you out about what you want to do, why you don't think cracks and breaks are that big a deal, why you do think penetrations are, and then I'm going to make a decision. So.
And if I could say, of course, if we believe that there's other people who need to be involved all the way up to Mr. Urquhart, then we'll make sure they're present. And I presume what you're really saying is a special meeting being scheduled in the future.
Yeah, in the future, like next week.
Okay, that's future.
I don't think these people out there are going to want to wait too long for any of this.
We're fine with that.
Okay.
We'll figure out a way.
Does that make sense?
Yes, sir.
I assume the owner's in agreement with that much. Association's in agreement? Okay. Then if the city has a contact person to speak to with regard to the owner, then you can coordinate something and we will convene down here at City Hall. Bring all your plans, bring all your specifications, bring all your drawings, bring whatever you want me to look at. Because every once in a while we have to do things like this. I will hear you out and then I will make a decision. Right now, what I'm remembering that you had to say was, if they don't convince me of anything at all, 6 weeks and they should be in compliance, and you want me to fine them already. I got that. So I'm going to have to hear from you folks. And your objective is to convince me there's something more to this than what he's told me about, and that proceeding to make the repairs that he wants is impractical because there's more to be done, and it would be economically foolish to do something you're going to undo later, or the benefit to be obtained by what you have in mind is so grand, it would convince the special magistrate it would be the best thing for the city, the residents, and everyone involved.
So
Your Honor, all we would ask for is to know which columns. There's 50 on each floor. There's 6 floors. There's probably 300 columns. We talking about 2 columns out of the 300? Are we talking? We really don't know, and it says columns. So if we can simply be shown, here are the ones that need to be fixed, we are happy to do it.
Is this something we've done already?
Yes, sir. We've walked more than once. But I have no problem doing it again. That's what we're here for.
Yeah, but
Step in there.
How much time? Take your time. I'm not trying to rush you when you want to do it.
Let's do it Thursday at 4.
Thursday at 4 o'clock, he's volunteering to appear at the parking garage, to walk around with you, and I guess mark whatever columns he has problems with.
Yeah, all the
about right?
cracks and breaks, yeah.
Is that the cracking and breaking we're talking about?
Yes, sir.
Okay, so when we're talking about cracking and breaking, we're just talking about columns.
No, there's also some in the floors and the ceilings as well, but
Well,
in the
that's what
interior of the garage, yes, I'm willing to go through all the items.
Okay, Thursday, 4 o'clock. Can y'all be available?
Sir, I would ask as well, my name's Natasha Herndon. I have met with Inspector Yates, attempted to meet on several occasions. Given the last walkthrough that we scheduled, I would request if you would kindly consider having another person such as a supervisor accompany him. I would like to make sure that we understand this column right here is the final issue. I'm glad to hear that Inspector Yates is acknowledging the work that has been done since August, September, October, November, and most recently in December. But I really would like the support, as you mentioned on the other project, of having someone else to kind of filter this so I can be very clear on, take a photo, I will document it,
Say
I'll
the
take
city did
photos.
this request. And I'm not.
Supervisor-
And Mr. Yates,
supervisor's
please
fine.
understand, I'm not passing judgment on anybody about anything. I'm trying to get from here to there. And I've got the distinct feeling that I'm crawling across barbed wire.
The division manager is sitting right here. Mr. Sykes will be happy to consider and address those, what your concerns are regarding Mr. Yates. I guess that's the best
Okay,
I
I'm not
can say
interested in their
and tell
concerns
you.
about Mr. Yates. They're suggesting perhaps another inspector or someone to accompany the inspector.
Accompany.
Mr. Sykes is nodding to indicate he'd be able to do that or have
Perfect.
that done.
That's what I wanted to hear. Thursday, 4 o'clock. Y'all have a representative there?
I will be there, and I am glad to document.
Mr. Yates and Mr. Sykes will be there. Very good.
Or someone that he assigns.
Pardon?
I say, or someone else he assigns.
Or someone else he assigns, whatever. Now, with that, are there a lot of columns to be repaired?
A decent amount. I'd have to go back over to
Decent
see
amount.
exactly how many, but yeah.
All right, well then, I'm going to assume we will still have to meet after this Thursday meeting. So, are you the contact? Then please give your name and number to our secretary, and she will coordinate a hearing that will follow sometime this thing on Thursday. And if the condo association wants to have a representative present as well, that's fine. Let me be perfectly clear there, however. They're there to watch and listen. I don't want any kibitzing. I don't want any 2 cents. I don't want any recommendations. I don't want any history lessons. Take it all in. No one's going to walk around with cell phones photographing each other. No one's going to be doing anything to create any disruptive atmosphere whatsoever. Capiche? Okay, does that cover everything we're here on today?
Just one clarification as to the special meeting that we will set. You would like that by the Friday following this Thursday? The next week, Friday, sometime in that week is what's ideal?
That'll be fine with me.
Okay, well, we'll
Wouldn't
see
think
if
we'd
we can
need more than
coordinate that
an
with the
hour.
parties.
And I'll just look, I wouldn't think we'd need more than an hour, but we'll coordinate that for the following week.
Okay.
Okay, we're getting ready to adjourn. Anybody else want to say anything before we leave? I already
Yes,
heard
Rick.
from you. Why am I hearing from you again?
Well, because I'm on the board, I was on the board of directors, and I'm infinitely involved with what has been going on. Just one short thing for the record. There are two completely separate issues with the garage. One is the cosmetic, and that's the violation.
You know, you're
There-
welcome to come to this hearing when we have it.
Oh, I'll be at it. I've been at every hearing so far about this since I took over 2 years ago. There is the puncture shear issue to talk about. It is not an issue. It was done by a computer model.
Hear it right
No,
now.
but
If I let you
Right.
talk, then I'm going to have to let him talk. If I let him talk, someone else is going to come out of the woodwork here that wants to talk. We're
Well,
done talking.
they've already said that's why they can't get in the garage to repair it.
You're going to talk no matter what. Is there anyone else out there in the audience that wants to be heard? Come on up, pal.
My deed says I own inside my room is the balcony. That's it. We don't own anything else.
Good afternoon, Magistrate.
Yes, sir. If you would please state your name and be sworn.
Carmine Rochapi.
Sorry, spell your last name.
ROCIOPPI.
Speaking to the mic.
ROCIOPPI.
First name.
Carmine, CARMINE.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Your Honor, I purchased this place to retire. My personal life savings went into buying this. This unit that we're talking about, this DBR, has been neglected for years and years. It's like the property's been walked away from. And we're over here arguing about whose responsibility is it. We have people here living in this place. This is their home. The man has an investment that he's not treating it as such. It's your property. Take care of it. You inherit it. Your grandfather broke his
Carmine,
nuts
do me
for
a
it.
favor and direct your remarks.
Okay. I understand, but it's just the outrage, Your Honor, because the property is so beautiful, was so beautiful. Take care of the property. Argue over the repair in court after you repair it. If I got you, brother. All right, I'm sorry, Magistrate. If we're responsible to pay for it, we'll pay for it. But you can't have a piece of property like this and just you walk into this place, you get disgusted. There's a garbage can in the hallway with feces coming down. I mean, just fix it. It's just so easy. Listen, Your Honor, it's mind-blowing if you... I mean, these guys know because they will walk the property. Maybe the owner, the developer, the builder needs to walk his own property and worry about who should be paying for it after it's repaired. If it's your decision and we have to pay for such and such, we pay for it. I'm done. God bless you, Ma.
Well, let me help you out here. First off, I won't be making any decisions whatsoever as it pertains to issues between the owner and the condo association and who's responsible for paying what. My job is to get the property in compliance, which I hope would be a benefit to everybody. And in situations like this, where sometimes it gets a little heated, I try to lower the temperature because I'm more interested in getting the job done than I am continuing to lob shots over a wall. So, not that I'm suggesting you are. So, all that having been said, I will let you and everyone else know that whatever I do, I'm sure it's not going to be satisfactory, because I'm sure y'all would love to see everything done as of yesterday. That having been said, I'm a lifelong resident of this area. I walk that beach. I drive that beach. I built the brick fascia for the very building you're talking about when I was 23-year-old laborer working for the construction company that added that parking garage and that tower that those condos are in, before I went to law school, obviously. In any event, I'm familiar with your building. I'm a citizen of the community. I want it to look nice as well. Looks beautiful from Halifax. Unfortunately, from the ocean, doesn't look too beautiful these days.
Correct.
We're going to get there eventually. Everyone's going to do what they're supposed to do, and they're either going to do what I tell them to do, or I'm going to fine the bejeebies out of them. And from the likes of what you heard from our inspector, those fines won't be paltry. So, all that having been said, everybody from here on out is going to do exactly what I tell them, or the fines are going to start flying.
Sounds like a plan. Put on the big boy pants and let's step up. Correct.
Good luck
Thank
to
you,
you.
Your Honor. God bless.
All right, folks, that's it for the two matters. Does that resolve all the matters that are before us?
That resolves everything that we have.
Okay. Owner's representative, anything more to be said? I'm hoping you're just going to say we're done for the
Nothing
day.
further, thank you.
Thank you.
Nothing other than to respond to say this is not just about money, it's about life safety.
You don't
That's
have
the
to
most
bother
paramount thing.
responding. I already know what the response is. Ma'am, we done?
Thank you for your time today.
Not a problem.
One thing I did want, I'm sorry, it's not
a dispute issue. You mentioned about cameras. Of course, the natural thing for inspection will be that there'll be at least the city doing its normal, whatever photographing if necessary, to aid in the discussion when we come before you.
If anybody wants to photograph the deficiencies for the sake of showing them to me, so I will know what they're talking about, they're welcome to do that.
You mean as to these parties?
What we're
that
not going to
before you,
do is
not
walk
all
around
citizens.
photographing people bickering with one another,
Understood.
intimidating one another, or doing anything else to try to chill the process I'm hoping to get accomplished so we can try to get all this done.
Thank you.
We're adjourned.